Hello and welcome to the Law 2023 Online Residential Property Shape the Debate with me, David Keithley and Richard Snape.
Hello.
Today's Q&A is scheduled to last 1 hour or thereabouts, and will cover pre-submitted questions. A recording of the event today will be available on the website within the next few days, so please keep an eye out for that. So just by way of introductions, I'm sure many of you have had the opportunity, or perhaps the pain of listening to me and Richard before. But I was admitted as a solicitor in 1982, and until I retired from full-time practice, I was a partner in and head of residential property at a Legal 500 firm, and I now use my experience and understanding of practical conveyancing to basically cut through the academic niceties and try and make things relevant for the busy practitioner. And amongst other things, I write for the Law Society Conveyancing Handbook. As part of the 2023 Law Online, my sessions covered new builds, points to consider, and an outline of capital gains tax on residential property. Richard has been the head of professional support at David James Bolt since 2002. He speaks at numerous courses for law societies all over the country and various public courses, in-house seminars within solicitors' firms, and has talked extensively to local authorities and central government bodies. His areas of specialism includes both residential and commercial property, in particular in relation to local government law, conveyancing issues, development land, commercial property, and encumbrances in relation to land. And Richard's recordings for Law 2023 Online were reporting to the lender and other hot mortgage issues, including new instructions on service charge caps and the latest on cladding, the real hot topic, and conveyancing issues and the family homes. Now, we have a number of pre-submitted questions. Some of them are aimed at my content, and some of them are aimed at Richard's content. So I shall read out the question, and obviously if it's for me, I'll then take the lead and answer it, and Richard will chip in if he feels able to do so, and vice versa. So I'm going to kick off with a question about the Building Safety Act. We say it is the real hot topic at the moment, and this is for you, Richard. The question is, what happens if a qualifying lease is extended after the 14th of February 2022?
Yeah, I thought I was going to have questions on this. I mean, when I first suggested the topics to the solicitors group, it was going to be a part of reporting to lender about what's been happening this year, ever since the lender's handbook changed and all the part 2 started to change in January. I thought it might just take over as the topic at the moment. Got to say, the Building Safety Act is it's the worst drafted piece of legislation I've ever come across, and that goes for somebody who had to talk about additional dwelling surcharge and SDLT when it came in 2016. They decided to change the provisions. This is why you got the date of February the 14th, 2022. It's gone through the House of Commons and much of the House of Lords, and then they decided to change all this. Introduce all these leasehold protection service charge caps, and everything crystallizes as to whether you've got the leaseholder protections on February the 14th, 2022. And strictly speaking, I mean, the lease must be in existence to get the service charge benefit of the service charge caps on February the 13th, 2022. And it's, from day one, it became quite apparent that there were issues there. And the one that's very much a talking point at the moment, I think it's changed. Things have changed since I did the recording that people have looked at, is if you go through a leasehold extension. Because if you go through a leasehold extension, as you'll appreciate, it's a brand new lease. It's a surrender and re-grant of the existing lease. And undoubtedly the case, if you go through a leasehold extension from February the 14th last year onwards, you've lost all your leaseholder protections. I mean, the latest, which wouldn't be in the recording, is the government changed their guidance on the qualifying date and qualifying leases firstly changed it on April the 6th of this year, and then they changed it again late in the afternoon of April the 21st as to what you should be doing about it. It's only guidance. I picked up on it on the Sunday evening, is when I picked up on it, because I thought it was a better bet than watching snooker. And they basically say that they are aware of the problem now, which they obviously weren't for many months. They will introduce amending legislation when time permits, but they don't say whether that's going to be retrospective or not. And I wouldn't hold your breath for it happening quickly. And you should, you, the conveyancer, should discuss the fact with the client that by going through a leasehold extension, you'll lose these leasehold protections. But you should also contact the landlords, and the landlords should be basically agreeing with the tenants that you introduce contractual provisions in the lease that give the same leaseholder protections. And I know what I would say as a landlord to that. You wouldn't get anywhere unless you got a higher rental, perhaps. But they say if you don't get anywhere with the landlords, then the leaseholder should contact the Department of Levelling Up and get Michael Gove on the case, and basically say who the landlord is and the correspondence with the landlord. But there's nothing the government can do about it until legislation. They're not breaking the law, these people. And it's all right to try and pressurize the developers into paying for remediation work and development. The landlords do not have to agree. So you've got to discuss with your client every last time the pros and cons of these things until we have a change of the law. And I suspect for people who are getting to that 80-year mark on the lease, where the mortgage, when you start paying marriage value on a lease extension, or you're getting to that stage where mortgagees say no in the 70-odd year mark, it's probably best to actually go through a leasehold extension.
Yeah, I mean, I think I was part of a roundtable discussion last month where there were people from the government in the online meeting, and it was clear in that meeting that they were unaware of a number of the issues that were cropping up, and this point about the lease extension was one which was very much flagged up. So I wasn't surprised to see the change, but as Richard says, it's there's no indication as to when it's going to be or if it's retrospective. And as you rightly say, as Richard said, a well-advised landlord is essentially not going to agree to voluntarily take on service charge liabilities or remediation liabilities that they don't have to do so in law. So it is a mess. And one of the many messes that come out of that badly drafted act. It's
not just badly drafted; it's ill thought out. I mean, nobody in government seems to realise that if the leaseholders don't have to pay for safety work with a service charge, and this goes well beyond mortgages, obviously, but if the leaseholder doesn't have to pay and the landlord can't pay, what happens? Insolvent landlord. I'm sure everyone's going to be happy with that.
I know that they've started to go after the developers and then get them to sign up to these compulsory contracts.
Well, basically because there's provisions in the Building Safety Act that if you don't sign up, you won't get planning permission.
But I think from what I hear, noises off is that the developers are saying, well, it's all very well coming against us, but what about the manufacturers of the cladding in the first place? Why are you not treating them? Yeah.
Well, the developers are sort of signing up to these schemes, but the manufacturers, the materials are not. Yeah. No one was in breach of anything at the time. People were getting building control on these properties. But that so goes, I say, a bit away from just the mortgage side of things, but it's worth stressing.
Of course, yeah. Okay, well, we'll come back to some other points on the Building Safety Act later, but I think we'll probably need to move on to something else. So let's take a question which was directed at me, which is, should I always, if my local search shows that the local authority has adopted the community infrastructure levy, does that mean that a payment is due to the council? Well, the issue is maybe not. I mean, it's the fact that the entries on the search doesn't mean that the property is actually liable to pay. I've certainly had this in practice where I've had inquiries raised to say that the local authority search shows that the property is subject to the levy. So please confirm that the levy has been paid. Well, the reality is, if the local authority have adopted CIL, then it will apply as a local land charge to every single property in that local authority's area. It will appear on the search. That doesn't mean that there's a liability, because the liability to CIL will only arise if there are new build works carried out which are within the scope of the CIL liability. It doesn't sort of mean that effectively there's a liability now on every single property, and even new build or extending an existing property can give rise to CIL, but equally there are a number of works you can do without liability arising. Some local authorities can choose to adopt a zero rating for CIL in some respects. But the key thing is that if it simply shows that the CIL is in force, then that isn't necessarily a trigger for the liability. You need to look further at the search, because it'll basically say, has there been a liability notice issued by the local authority in respect of this property? And if the answer to that is yes, then it's a completely different situation. Then yes, there will have to be discussions with the sellers to make sure that the liability has been paid. And it's a question there of, if you're acting on a new build and there's a CIL liability, should you be insisting that the developer has paid it before completion? I think there's a very strong argument for saying yes, that you should, because the liability will eventually, if the developer doesn't pay it, it will revert to the landowner. So it's a question of looking at the surrounding circumstances and making sure that the liability is cleared off. But the fact that it's on the search isn't going to mean that there's automatically a payment due to the councils. I don't know if you want to add anything to that, Richard.
Yeah, and like you say, then the search tells you whether the levy's in place in that particular local authority area or not. It doesn't necessarily, it doesn't tell you whether it applies to that particular property, because local authorities, they adopt the levy, and the liability stems to any planning permission granted from the day afterwards. Like you say, they can have zero levy, and there are quite a few exemptions, like self-builds with quite a few provisos and all that. Yeah. I don't know if you were talking about them. Yes,
I did mention those. I mentioned it in the notes about the exemptions. I also covered the fact that the regulations around CIL are quite prescriptive, and you can fall foul of them very easily.
Yeah, in terms of self-builds and the notifications. Yeah. Yes, I'm here in Cheshire on a quite sunny day, actually, and in the distance with my telescope I can see the self-build that Wayne Rooney designed himself, and boy does it show. It looks exactly like you'd expect Wayne Rooney's design to have it look like. But anyway, I think, going back to your point, the most important thing for the conveyancer acting for purchasers of, like you say, not just new builds, but potentially others besides, is the fact that if the developer or whoever's responsible for the levy doesn't pay it, the local authority is duty bound, or the planning authority is duty bound to pursue the purchaser.
Yeah.
They don't have any discretion in the matter. If it's a Section 106 agreement, lots of local authorities will make them personal.
Yeah.
I've seen some local authorities say that they're going to make the sale personal to the developer. It's not up to them.
Yeah,
they must issue it, and they can be incredibly hefty. I mean, the local authority's got the biggest sort of range of levies, is probably where you are in Cornwall. There are some parts in the middle and the tin mining areas of the past, there's zero levy, and fashionable North Coast and likes and around Carrot Roads, it's 400 quid per square metre last night.
Yeah, indeed. Yeah, they're quite hefty. But I think you're right. I mean, the critical thing is, if you're buying a new build, is make sure the developer has paid it. Because ultimately, yes, it will. It could come back and bite your individual client. But
I'd also say, I mean, I don't know if you dealt with this, but one of the problems I suspect you're going to have going forward is that these things will be showing up on local land charges, which is where you find out whether it applies to that property. And they'll probably never been taken off once the money's been paid.
No, I mean, again, local authorities, we know are sometimes quite bad at updating the searches. So yes, inevitably it's going to be a problem moving forward. But I mean, it's like many things. I've had people sort of say, well, there's a planning enforcement notice. I know we're going off point here, but planning enforcement notice which was served 25 years ago prior to on a different use of the land. Yeah, and they're insisting the local authority remove the notice. Well, they can't. The notice has been served, it's there. They can make a note that the notice has been complied with, but the fact that the notice has been served is a historical record and can't just be magically made to disappear. So, but equally with the CIL, yes, it's the liability notice may have been issued. Remain to be seen if the local authority will update it. I suspect that may not be made any easier by the transfer across to the land registry, which is going as badly as predicted. And I've certainly heard stories, in many cases, of whole swathes of information just not being transferred across from the local authority to the land registry.
Well, you might be like Hackney, you've been hacked into and lost all their local.
Yeah, exactly. Yeah, there was one I heard recently where all of the tree preservation orders and the listed building records were just completely missed off.
I've seen all the listed building records. In fact, it was all the conservation areas have been don't show up.
Yeah.
But that's another topic. Yeah.
Indeed, yes. I haven't got time for that one.
No, David, what kind of saddos hack into local land charges? But
yeah, I'm sure the Russians have got better things to
there is
do.
some sick people out there.
Probably
Anyway.
disgruntled conveyancers, or disgruntled.
Well, they're just saying take out no search insurance, basically.
Yeah, indeed. Okay, so let's move on then to another one for Richard. If you obtain receipt of mortgage money from two trustees, what happens later if there is only one trustee?
Yeah, the same would be the case with purchase price. It's a bit of conveyancing I've never understood, actually, why people don't distinguish it in practice. If you get receipt of capital money, mortgage money or purchase money from at least two trustees, any beneficial interests in the land are overreached and converted to the proceeds of sale, held on trust. There's the proceeds of sale, but you can guarantee vacant possession. Section 27(2) of the Law of Property Act. And it was confirmed in as they were, House of Lords case called City of London Building Society in Flegg as long ago as 1990, I think it was. And strictly speaking, you don't need to sign consent to mortgage forms or sign the contract. You get vacant possession. And it's not a bad idea, I should say, to get people to sign anyway. And it's probably a bit too difficult to explain to the mortgage company, we don't need this. Once you've got receipt of capital money from at least two trustees, doesn't matter what the status, if there's only comes one trustee at a later stage, you've still got vacant possession guaranteed. It's a much easier thing to deal with if you're getting receipt of capital and guaranteeing vacant possession.
Yep, I agree. I mean,
I say it's one of those things that people do in their degree level land law studies, and then as soon as you get into the real world, you conveniently forget it.
Yeah, indeed. I mean, I think one of the things it's a bit slightly off topic, but I find that you get people who, where there's been a couple who have held property as tenants in common, and one of them has died, and they've simply lodged the death certificate at the land registry because that doesn't remove the restriction. So it's sloppy conveyancing that is part of the issue. But as you say, once you've got the receipt from two and you've got your possession, then you're not worried about what happens afterwards. In the same way that you pay the money to the trustees, if they misappropriate the funds, that's not your problem as the purchaser. You've complied with the requirement. It's the trustees' liability then to the beneficiaries, not you as the owner.
I think the legislation is supposed to be based on the fact you might get one crooked trustee, but you will never
get two. You won't get two. Yeah.
I think you allow the first trustee to appoint the second trustee. That's how much it works. But it's also, I mean, because I touched upon in it was the family home course, not the mortgage course, but things like the need to think about undue influence and likes. And if you've got two trustees, you're not overly concerned with independent advice, not suggested.
Okay, yeah, good point. Okay, so move on to another one for me, slightly contentious one. How likely is it that the local authority will seek an injunction in respect of building regulation breach? Well, the hot topic, isn't it? This is a bloody case, so pardon my expression. The reality is, I mean, the Section 36 of the Building Act is quite clear that the local authority has 1 year from the validity of the works to take enforcement proceedings. But as the courts have said, there is in theory, there is the possibility that the local authority could get an injunction after the 12-month expiry. The question really is, what's the likelihood of that actually happening? Now, the issue here is a risk issue, I suppose, to some extent, but equally, what's not widely appreciated, and I did actually cover it in the session, is that in 1998 the government produced a concordat in respect of enforcement, and most local authorities have signed up to this concordat. And essentially, it means that their enforcement has to be proportionate and has to take into account the risks, etc., to the public of the likely of the breach. So the reality is that if you've, for example, had your windows replaced by somebody who's not FENSA registered and you didn't get building regulation approval, then I suspect the chances of the local authority using public money to take out an injunction against you for your windows is pretty slim. If, however, the work you've carried out had carried out is so unstable as to represent a risk to the public, then I suspect they might well be within the bounds of enforcement. But the reality is that I think most local authorities have got better things to do with their money than to start pursuing people for historical breaches of building regulations, certainly if they've signed up to the concordat. Now, obviously, the other issue is, do you take out building regulation indemnity policy? Well, I don't want to get you started on that, but essentially, a lot of clients need to appreciate that the policy covers you against risks of enforcement by the local authority. Well, if the risk of enforcement by the local authority is zero, then the policy isn't really providing you with much cover. If the work turns out to be defective, it's not going to be providing you with any particular benefit. So you will get people come back and quote the Natty Bauer case at you. I think it's worth just throwing back the concordat to them and saying, well, does your client survey show that this is a risk to the public, or that the building is at risk of collapse because of the works that's been carried out? You'll never get away. You'll never get some people to accept them, and there are some firms, as we know, operate on the guide. I had one discussion with a firm who said that their policy was that if there'd been any works carried out to the building at any time since 1948, irrespective of whether there was building regulation or planning permission, they wanted an indemnity policy. My view was I refused to do it on the grounds I refused to make a donation to the underwriter's beer fund, because it was just a complete waste of time and money. But it's sometimes you just take out the policy just to get the thing moved on. Whether it's actually any merit to it, well, that's another matter.
Yeah, the trouble with the policy is, 15 quid or something for a policy, and you can waste a lot more fee and time arguing the case with the other side of the case.
Yeah.
But I have actually come across a couple of occasions in my very long career of local authorities actually getting injunctions years down the line. But a couple of occasions, and how many, I shudder to think how many, they don't have the resources. I mean, local authorities not going to think to themselves, this property is a death trap, but a year's passed, there's nothing we can do, they'll have to die. They will do something about it, but they don't have the resources to go around policing the whole of their local authority area. There is also, perhaps worth mentioning, is provisions in the dreaded Building Safety Act again, which allow the enforcement period to go from 1 year to 10 years.
Yeah.
So we'll have to see what happens there.
Yeah.
I think the consensus is amongst the insurers, in fact I know because I've talked to them, if it does go up to 10 years, then it won't change much in terms of premiums and the likes, unless there are claims, and then the premiums will start to go up. But I don't, even if it went up to 10 years, local authorities won't have the resources.
No, so I did do an in-house session for a firm in Hampshire, and this point cropped up, and they pointed out that their local authority was one of the local authorities that had actually taken enforcement proceedings against a builder who carried out work to his own house that was so slapdash that they were actually there was a risk to the public of the property falling down. So that was always by my own petard as far as that one was concerned. But,
you see, I've got on LinkedIn, I put people being putting their stories and like commenting on my post, and one of them was that they built a living room extension, which needs building regulations, and so the solicitor's asking, please provide building regs for the living room extension, and the response came back, we don't need building regulations because we built the extension ourselves. So that's the answer.
Yeah.
You do worry about these people.
You do. Okay. Right, well, you touched on the Building Safety Act, Richard, so let's go back to that. So the question that's been submitted is, what happens if the leaseholder on the 14th of February 2022 was an executor?
Again, this is the most kind of contorted legislation because then it didn't go through scrutiny. It seems, I mean, basically, at the beginning of February the 14th, 2022, for all those people who decided to move on Valentine's Day last year, you can have up to 3 dwellings anywhere in the UK, and you can claim on them. You can always claim on your principal home, but if you've got more than 3 dwellings anywhere in the UK and not just flats, you can only claim on your principal home. And another thing I'm pretty certain they didn't think about is executors. It's not impossible, but it's highly unlikely to be their only principal home. Lots of solicitors have been asking me about this because they've been the executor as well. And it seems that as long as you don't have more than 3 dwellings, the estate had more than 3 dwellings in the UK, you should be okay. But if you do have more, then you won't be okay because it's not your principal home. And that seems to be the case.
The other issue, which has certainly cropped up in relation to that, and it was something that popped up on this roundtable session I spoke about earlier, was what happens if the deceased died on, let's say, the 10th of February 2022. So on the 14th of February 2022, there was nobody living there. It was nobody's principal.
Yeah, I've had people asking me about that. What if they're in long-term care?
Yeah, exactly. So the situation is at best unclear, and that was certainly flagged up in that session. The issue about the solicitors thing is if you've got an appointment that says that the executors are the partners in the firm and there's 10 partners, does it mean that you're only looking at the names of the executors, the partners who actually take out the grant? Are you looking at the houses they own, or do you need to take into account the houses, all of the other? So it's just badly thought through.
And also a company leaseholder, because a company there's no principal home.
No, exactly. I mean, that's the other issue, isn't it? If the leaseholder is a company, then on the face of it, they do appear to fall outside the act, as you say.
And it does seem, though, that you can have up to 3 dwellings in claim. But it's when you've got more than 3 dwellings, you can only claim for your principal home. And if it's a company, you can't claim because it's not your principal home or an executor.
Well, I think that many things with the Act, it is, I say, badly thought through, terribly drafted, and this is one thing that just is cropping up. I mean, it's almost as if the government seemed to assume that nobody would die after the 14th of February, before the 14th of February 2022. I mean, it's a bit of a.
It's like the leasehold extension stuff. Going back to that, I don't want to make it a Building Safety Act course because it's supposed to be just part of the mortgage course, which I might update on that in a minute. But how many people have gone through leasehold extensions between February the 14th last year and now?
And now, yeah.
They've lost their leasehold protections.
Indeed. I mean, there's also, I mean, again, we're getting a bit off topic, but there will have been people who bought houses last year before the Act came into force. And they wouldn't have been the owner on the 14th of February 2022, and now they might be coming to sell. And according to the legislation, it seems that they're required to make contact with the previous owner to establish the status of that previous owner on the 14th of February 2022. Well, that might be fine if you're dealing with a sale now. You might still be reasonably capable of contacting the previous owners, a year or so after you bought. But if we're talking 3, 4, 5 years' time, and somebody has to make contact or try and make contact with the owner on the previous owner, then that's going to become increasingly difficult.
Historic official copies and the likes of that.
Yeah, but again, if you don't know how many homes that person owned, I mean, it's very difficult, isn't it? So,
I mean, bizarrely, I mean, you can again have 3 dwellings in the UK, and you can claim. You might have 3 dwellings in the UK and 50 in Europe.
Yeah, exactly. Yeah.
And you're okay. If you've got 4 dwellings in the UK,
your
principal home, then you can't claim.
Yeah.
And if you buy from somebody who's a full, investor, with 4 dwellings, and you buy today as your principal home, you don't have the rights, you don't have the benefit,
protection.
If you are an investor buying from somebody who was their principal home on February the 14th, and they've got 100 properties, they do qualify.
They do qualify. I know it's badly thought through, isn't it? But in terms of my slight concern I have is that if you, as a firm, acted for people who bought, let's say in May of last year before the Act came into force, the chances of you still being on your retainer, which the registration probably hasn't gone through yet with the land registry being as efficient as they are, then you're probably still on the hook for the retainer. So the question is, should you be approaching those clients and pointing out to them that they really should be getting the leaseholder certificate in place now from the previous owner? And there's an argument, I suppose, for saying that you still have a duty of care. So it's an argument for saying you should be at least thinking about approaching your clients in that situation, and if nothing else, just as a means of cementing your relationship with them. But I'm sure they won't thank you if in 3 years' time this crops up and realise that you perhaps should have raised the point with them much before. But it's a difficult one, tricky.
And don't forget as well, bringing it in where I originally intended to be in the mortgage company, is the mortgagees require these documents.
Yeah.
And they, can I say something about Wales?
Of course you can.
Because we haven't a clue what's going on in Wales, because all the legislation, all 161 sections and the 11 schedules of the Act, the Building Safety Act, apply to Wales. But they gave the Welsh government they delegated the power to decide on the height of the building. In England, it's 5 stories or 11 or more meters, which Barclays doesn't seem to realise. I should check on their new Part 2s whether they've spelt stories correctly finally, actually. Because stories as in a tale and a fib, which Nationwide certainly still do, which is probably more apt, actually, a tale, a fairy tale. But in Wales, we're still waiting for the Welsh government to announce what the relevant height of the building is. They're still considering on it. So I did a course in Cardiff, and you have to mention all this is going to be enforced, all this is enforced now. But we can't advise anything unless we know what the height of the building is. Yeah,
they do. I did a session in Bristol. One of the feedbacks was that I didn't make any reference to what was going on in Wales, and the answer is because nobody knows what's going on in Wales at the moment. So it's a bit of a problem one. But it's just the point. Sorry about you mentioned about the handbook there. Again, I keep coming back to this round table thing. There was a person in the room from UK Finance, and it was pointed out. I pointed out to them that the Part 1 is so badly worded because it refers to all leasehold properties. So you're having to raise questions about leaseholder and landlord certificates in a building that's completely irrelevant because it's less than 11 metres or 5 stories or whatever. And the response back was that UK Finance were aware of the issue and that they were working on amending the Part 1s to...
How long does that take?
Well, exactly. I mean, that was thick end of a month ago, and they said they were working on making the change. Well, it's the wording is relatively straightforward, isn't it? It's the moment it says if the property is a leasehold flat. So if you've got a maisonette, then on the face of it, you need to be asking the seller solicitors if there's a landlord and leaseholder certificate in place, because that's what the lender wants. Yeah, completely pointless, because the chances of the maisonette being more than 11 metres in height is pretty slim. It certainly won't be 5 stories. So we're sort of we're in that situation. I'm doing this in practice at the moment, where I've had to ask questions and ask people for things which I know are completely meaningless, because that's what the lender insists on having, which is a bit pointless. And the measurement of the height—that's the other issue, isn't it? I mean, 11 metres.
I think that's a surveyor's job.
It is a surveyor's job. You're right, but the
value is they ask your solicitor.
Exactly, but it's not. The measurement is not to the roof, is it? It's to the floor of the top floor flat, and it's not a measurement that is sort of readily available. And the question which comes up is, how does a solicitor know, whether the building is more than 11 metres in height? Well, the issue is you have to throw it back at the seller's solicitor, or the seller's surveyor, or the buyer's surveyor, or anybody. It can't be the buyer's solicitor's responsibility, but ultimately, I suppose it will end up on their on their lap, because they're the one on the hook to the lender. So it's what do you do if you're a buyer's solicitor and the building is 4 stories high, but you think it might be more than 11 metres? How on earth do you get it verified whether it is 11 metres or not?
I sometimes wonder if that sort of measurement up to the bottom, to the floor of the top floor, unless it's plant and machinery, is a mistake or not.
Possibly.
If the higher risk building stuff has come in, at least, then they refer to the ceiling.
There's some. I mean, there are some pretty diagrams on the government websites with all sorts of, showing how you measure and if the land is uneven and all the rest of it. So, if it was a mistake, they've cemented it by drawing these nice little pretty pictures to put the information out there. So, wait and see. But again, okay, let's move away from that. So let's move on to a question relating to capital gains tax, which is, am I always required to advise a conveyancing client on capital gains tax? Well, let's have a think about this. I think it's a question of making it clear in your terms of business letter. The issue is that it's implicit in any conveyancing retainer that you give advice on matters which are reasonably incidental to the transaction. So that would imply that giving advice on capital gains tax is basic advice, is perhaps implicit in the retainer. But if you're not confident or comfortable or feel qualified to deal with capital gains tax, and an awful lot of solicitors don't, on your grounds that they think it's an accountant's tax, and I don't disagree on that, then I suppose the way forward is to make it clear in your terms of business that you will not be willing to advise or not going to advise on issues in relation to capital gains tax, other than perhaps pointing out to clients. And there's another question which I'll pick up at the same time here. One of the questions which came through was, what do I tell a client in relation to capital gains tax if they're buying a property that's got 2 acres of land? Well, if the main home exemption only applies if the grounds of the property are less than 1 acre. So I suppose if you're buying a property, acting on the purchase of a property where the grounds are 2 acres, then it's probably implicit in the retainer that you point out to the client that the main home exemption might be at risk when they come to sell, and suggest that they seek detailed advice from a tax expert or an accountant. So, but I think that's probably about as far as most solicitors would be comfortable to go. But the fact is, am I required to go into detail about capital gains tax simply because I'm acting on a purchase? The answer is, it depends on what you've said in your letter, I suspect, in your terms of business letter. If you haven't excluded the liability, then possibly yes. So I think the best thing to do is to limit the extent of what you're prepared to do within the letter itself. And there was a third question on capital gains tax, which I can sort of pick up at the same time, which is, does working from home mean that the main home exemption from CGT is totally lost? Well, possibly not. Possibly, but possibly not. I mean, the main home exemption applies in various circumstances, but it is lost if part of the home is used exclusively for business purposes. So here I am, and Richard's the same, where I'm working from an office in my house. It's not totally used for business purposes, as you might see from my collection of books and bric-a-brac and other things behind me. It's also, a room used for domestic purposes. So it is not exclusively used for business purposes. But I suppose the question is, if, for example, I was fortunate enough to have the land available and indeed the means to build an office, dedicated office at the bottom of my garden, and that is used exclusively for business purposes. I might even have my assistant or somebody working in there with me. Does that mean that I've lost the main home exemption? Well, again, it's possible, but that's not something I think that you and I ought to be getting too deeply involved with. So that's an accountancy issue. But I think the simply working or running a business from home and using a room incidental to its residential purposes isn't going to automatically disqualify you, but there might be circumstances in which the exemption could possibly be lost. And like many things with capital gains tax, is just make sure you limit your exposure by putting the limitations within your terms of business letter, or your retainer, as the academics like to call it.
You can see my tax deductible Moorcroft in the background.
Sorry?
My tax
your collection of Moorcroft, yeah.
All tax deductible, I'm sure.
Of course, yes, of course. Yeah. Proving that that's not being used exclusively for business purposes.
But I think I agree entirely. I think you've got to limit your retainer. I think some firms tend to be a bit too reluctant to do that, and think they should do a bit of everything. You shouldn't be given. I think you limit your retainer. So apparently now we're all supposed to be telling clients about climate change as well.
Yeah, God, yes.
But you limit your retainer. We do not. Not
we're not qualified to advise on climate. I mean, I'm getting off topic again, but I profoundly disagree with the Law Society edict saying that there's a duty to advise. We're just not. I have to say, I profoundly disagree with that. We're not qualified.
I don't think most conveyancers are qualified to give detail. I think you can make clients aware. And I think the same goes for stamp duty, land tax. Quite.
Yeah, maybe. Yeah.
Certainly for inheritance tax, and you leave that to private client people.
Perhaps it's me being cynical, but this sort of pressure to advise on climate change seems to come about the time that indemnity policies and other things, the products were available in respect and searches for climate change. So, okay. I mean, I suppose if you're acting for a client who's buying a house right on the beach or right on a cliff top that is liable to be, if the sea levels rise, they'll be washed away.
It does say in the Law Society guidance on climate change that you should, for instance, be telling clients that if they buy a house on a floodplain, it might flood. This was news to me.
Well, indeed, yeah. And so how come the developer got permission to build on the floodplain in the first place? But, what they don't explain is how do you advise if your client is a climate change denier? So of which there are many. You could end up in a sort of a political argument with your client about whether climate change actually exists in the first place. But
I think lawyers should be much better than some are. Not all, but some are just limiting your retainer. This is what we're here to do, and this is not what we're here to do. I've always thought collectively surveyors are much better at that.
Yeah, of course. But I think again it's the same thing. If you're updating your terms of business letter to take out tax, then take out climate change as well. And basically just sort of saying we're not prepared to give anything more than just basic advice. As you said, the point, if you're buying a house next to a river or on a floodplain, it might flood. So yes, I mean it might flood. And I had a situation years ago when I bought a house for somebody on the seafront in Dorset when the cellar of the house was below sea level. Well, yes, that flooded. Of course it did. It was, but do you need me to tell you that you buy a house that's got a building below sea level and you're 20 yards from the sea, that there's a danger you might get water coming in? Where do you draw the line? I did hear one time of a firm that was being pursued for negligence by a client who bought a house close to an airport on the grounds that they hadn't told them that their house was close to an airport. And you think,
There are telltale signs.
where do you go? Where do you go? Yes, it's sort of this big thing at the end of the road where aeroplanes kept taking off and landing. You haven't noticed it. But, anyway, there we go. Right, so let's move on then to another one for Richard. Are there any situations when acting for co-owners you should insist on separate representation?
I think very rarely, yeah. I think you should always, whenever you're acting for co-purchasers, I mean, married, as I mentioned in the course, actually, the family home course, to some extent, married couples and civil partners are the best to deal with because the declaration of trust and the likes has nothing to do with, if there's a separation and breakdown, it's the divorce courts which get involved. It's anything else, and not just cohabitants, but co-ownership generally. And you've got huge scopes of potential conflicts of interest. If one party is plowing in 9/10 of the purchase price and the other side's plowing in 1/10, there's huge scope for conflict of interest between the clients if they want to be joint tenants beneficially. One person stands to gain a lot and one person stands to lose a lot if the relationship breaks down. And I would always suggest that they can be separately represented. It's probably easier to spot if you actually saw it, if you saw your clients in front of you, where you might insist on separate representation. I came across one, it was years back. I'm not sure if I mentioned this in the course actually, in the recording, where the client had recently gone through a messy divorce. The same firm of solicitors had handled the divorce, not the same solicitor, but the same firm. And she got the whole of this house, no mortgage, £500,000 or so plus, and this was a few years back. And soon afterwards, she's there with a new man in her life who was very much her junior, wanting to transfer into joint names. It's not exactly to the point, but she was obviously leaning on the man for support. And the solicitor said, I'm going to have to advise you, we've got minus your partner, and this is not optional. And she wouldn't accept that. And so he refused to act. If you think there's sort of clear undue influence, I think you should, if it's clear undue influence, whether you should be acting. If one side stands to lose a lot more for no apparent reason than they stand to gain, I might just think about separate representation once or twice in your career.
Yeah, I mean, we do, we have very clear responsibilities. If there's evidence of undue influence or duress, then we do have obligations to act in the best interests of our clients. And I agree. I mean, like you in practice, I have not very often, but there have been circumstances when I've had to say that that I'm insisting that you get separate representation because you say the stances of the two individuals are so completely different. There's also an argument if somebody comes to you and says, "I want you to do as a declaration of trust." Should you be acting for both parties if they're, for example, unmarried couples in a declaration of trust? Can you advise both parties? If they say the declaration of trust is that it's 50-50, and where you can see that they've contributed equal amounts to the purchase price and they're paying equally to the mortgage, then that may be so. But if they say I want a declaration of trust where it's 99% and 1%, then it may be a slightly different issue.
I think the more dangerous, and this is not meant to be sort of said in a derogatory way, I think it's probably elderly parents and adult kids buying together.
Yeah.
That's the one where you might just be,
a
bit, suspicious. Lots of elderly parents are more than capable of looking after their interest and rights. If the elderly parents selling their house, which is worth $500,000, and the kids are selling theirs, which is worth $200,000, and they're becoming 50-50 tenants in common or whatever. Yeah, I think I'd be a bit worried about something like that.
Yeah, no, I agree. It's a question of just watch out for the warning signs more than anything, isn't it? So okay, right. I'm just conscious of time, so I'll crack on with one more for me, which is should I, which we can deal with quite quickly. Should I always insist that the developer solicitor gets a land registry approval of the site plan? the issue is it's not essential, but it's certainly best practice, I'd say, and it's more, you're less likely to get requisitions if the plan has been approved beforehand. That doesn't, however, of course, take away the other problem, which is they might have had the site plan approved, but if they don't put the fences up in the places where they put them on the plan that have been approved by the land registry, then that may well trigger issues when you come to deal with the registration. So yeah, you can't insist that they get it approved, but certainly there will be circumstances where I think it would be certainly advisable that they get it approved. Do you want to throw anything on that, Richard?
No, I think that's basically right. Yeah.
Yeah. Okay. Right. We'll take one more. Might be the last one in relation. Probably relevant for Richard. Should I report anything to the mortgage company in relation to higher risk buildings? Yeah, bit of a curve.
Yeah. Again, this is sort of a higher risk building is basically it's either 18 meters or more in height or 7 or more stories with dwellings in it, with at least one dwelling in it. And it's quite separate. It's part 4 of the Building Safety Act as opposed to part 5. I should also stress that in Wales, we're still waiting for the height of a higher risk building. So this is just for England. And the legislation started coming to force in England on April the 6th. We're now on, what's the date today? May the 3rd is today. So it's sort of 4 weeks old. There's a lot of legislation on it, but somebody called the accountable person, this person who had an interest in possession in the common parts or repair and maintenance of the common parts, can't let anybody into residential occupation unless you've seen building control first. But B, we call the principal accountable person, has to register the high risk building with a branch of the health and safety executive called the building safety regulator. Again, this is all post-Grenfell legislation. And the registration started on April the 6th, and you're supposed to register by October, otherwise you maximum 2 years prison and unlimited fines. So I can sense we had 5.14.17 of the lender's handbook, the stuff with the leaseholder protections, the service charge caps at the beginning of the year. I can sense a 5.14.18 coming. And I can also sense a new TA7 and LPE1. They changed on January the 9th. And I think we're going to have inquiries about that. And before that, I think certainly by October, you'd need to verify and report accordingly that the high risk building has been registered with the regulator.
Properly registered, yeah. Again, I mean, in terms of the height issue, it's you've still got the same point of knowing. But if it's again, you're talking about more than 5 stories, then you're getting into the higher risk territory. It's going to be easier.
Yeah.
It's easier. Yeah, sorry. Yeah,
I'm pretty sure they say in the legislation, and don't take me up on this, that you measure the height of a higher risk building to the ceiling as opposed to the.
I think that might be right. Yes, yeah, so it does seem odd in conjunction with the other one. And the issue is if they are going to change the LP one, I agree that probably will be needed. Why not put in the requirement for the landlord to declare the height of the building, to be responsible for declaring what the height of the building is from the floor to the base of the ceiling or the base of the top of the floor, depending on what is the appropriate thing. Because the landlord or the managing agent, they will know, they should know.
The accountable person should know.
Should know, yeah, exactly.
Who is the person with an interest in possession of the common parts or repairing obligations to the common parts, so the immediate landlord anyway.
The immediate landlord, and the managing agent may, if they're doing the LP1, the managing agent's probably acting potentially on behalf of the immediate landlord, or if not, then the garment holder. But it would seem a sensible thing to me to put it in the LP1 somewhere, so that it's.
I think it's you're going to have a change to the lender's handbook.
Yeah,
make it clear. But in the meantime, certainly come October, I'd report the lack of registration, and also it's not just new builds that you need to see building control certificates and likes before anybody can go into residential occupation. It's the new build blocks, but it's also the conversions, if they're sufficient height, if you convert the office block into residential, added flats and the likes. They reckon it's about 12,500 plus blocks in England alone. That's an extra 500, 490 every year.
Okay, well, I think that's all we've got time for today. So thank you for watching the 2023 Law Online Residential Property Shape the Debate. Don't forget to join the solicitors group LAW2023 Online community on LinkedIn to continue the debate and to be included in exclusive offers for future events. And continuing debate probably means that ask more questions for Richard and me. But anyway, if you have purchased the online course, there's still time to watch the pre-recorded content. Your expiry date will be displayed next to the webinar. For those of you that haven't, there's still time to buy the complete event, including a recording of this session. To book, just go to the solicitorsgroup.co.uk, where you will also find the online exhibition. That exhibition is open to anyone to visit, and if you have booked the entire package, you can claim your free 1-hour CPD webinar from the webinar learning catalogue, which is worth £35 plus VAT. Finally, after viewing the online course, please complete the feedback form, unless you're being rude about Richard and me, in which case don't. The feedback form is available in the related links section, and you'll receive your CPD certificate via email. Sorry, being flippant there, but obviously if you do have comments to make about Richard or I, then please do so. They are.
That's David, not me.
Yeah, well, yeah, all right, yeah. They are taken on board, believe me. Anyway, so thank you again for listening, and thank you, Richard, for your input. And everybody, please have a great day.
Okay, thanks.